Hello, I am Sam Goldstein. I am the Director of Legal Affairs for Bnai Brith, Canada. Bnai Brith is Canada's one of the oldest human rights organizations in our country. We've been around since about 1875. And as part of Bnai Brith and as Director of Legal Affairs there, I'm also in charge of the Matis Law Society. The Matis Law Society is a national Jewish lawyers society. We fight anti-Semitism and promoting human rights for all people in Canada. It's named after David Matis, who is a Winnipeg lawyer still practicing, and he's been involved in many of the leading cases for human rights in Canada. I'm really pleased to be moderating this event. You're probably wondering, why is some Canadian dealing with an event with the UKLFI Charitable Trust? And let me tell you a little bit of the story. Many years ago, I think back in 2010, your former head of the UKLFI, Yonatan Turner, he and I met at an event that was being sponsored by the Israeli Ministry of Foreign Affairs in Jerusalem. He put me on to your list, and I've been watching your events, and for a very long time now, I've been wanting to do a joint program between the Matis Law Society and the UKLFI, and finally I was able to get in touch with Jonathan, and we talked about an event, and I think this is a perfect event for it. I'd like to welcome our other speakers. Now, unfortunately, Natasha Hausendorf is not available today. She had a bit of an accident, and the doctor told her to rest, nothing serious, but unfortunately she's not going to be able to be with us. We obviously wish her well, but sitting in for Natasha is Yonatan Green. Yonatan Green, who I hope will be popping up any moment now on your screen. There he goes. Yonatan Green very generously stepped in for Natasha. Yonatan is an Israeli lawyer, also called to the bar in New York. He is presently with the Law and Liberty Forum. If I got the name right, the Law and Liberty Forum in Jerusalem. It is a conservative leaning society trying to promote conservative interpretations of the law. If I got that right, if I got that wrong, Yonatan, you could correct me. As well, we have Ryan Alford, Professor Ryan Alford, a very good friend of mine. He teaches at Lakehead University in Ontario. He teaches constitutional law. He's a constitutional historian. His latest book on the topic is The 7 Absolute Rights. It is a great book on constitutional law, particularly constitutional law in Canada. So let's get started. This event is about the judicial reforms going on in Israel now. I know many of you probably have some issues with it, and I last time the UKLFI had an event on, I kept listening to the discussions. I kept thinking, as a Canadian, some of the reforms aren't so strange to my ears. Now, as we all know, Israel, when it became independent, Ben-Gurion gave it a Declaration of Independence, but it didn't have a constitution. Much like up until about 1995, when the basic law was passed, suddenly the Israeli Supreme Court started having the ability to actually invalidate laws. Much like in Canada, where in 1867, our Supreme Court didn't have the jurisdiction to invalidate laws, and we didn't get that until the Charter in 1982. So some similarities there in terms of history. Some people see that there is an imbalance between the Knesset and the judiciary, and some people see that what's going on now is really simply trying to rebalance or calibrate what that balance should be. So, Yonatan, if I missed out on what you do, please fill us in if I missed anything important. But why don't you begin with talking about sort of what's going on in Israel right now?
Thank you very much, Sam, and thank you everybody for joining us. Thank you for the generous hosts, and obviously sorry Natasha couldn't make it, and I don't think we'll be able to measure up to the formidable Natasha Hausendorf. If it's any consolation, I should say, especially to our English brethren who are watching, that I am of English heritage. My mom is British. My grandmother was Joe Wagerman, who was head of the Board of Deputies in the UK and head teacher of the JFS. Some of you might be familiar. So at least I have some claim to be partially representing the UK sort of perspective here in this conversation. Look, obviously, there's a huge amount to say about the reforms in Israel, and in that sense, I think it's probably best to skip directly to the specific questions that we had, Sam, about what the more specific things that you wanted to talk about. Because if we start going into general background, there'll be no end to it, and I'll address background issues when we address the specific questions.
Okay, so one of the issues then that I think Netanyahu is trying to get at is the issue of a parliamentary, in this case, a Knesset override. So this is not unknown to the Canadian situation, but as I understand it, it's a bit foreign to the Israeli situation, at least after 1995. Why don't you sort of talk about what he's suggesting in particular?
Right. So I should say, I mean, I know abroad it's sort of common to talk about Netanyahu because he's sort of the more familiar face in the Israeli political landscape. But this is certainly, I think, broader than him personally. And there's a great many legislators as well as a large sort of grassroots movement which is behind this. And the people who are most sort of associated with these reforms are probably Justice Minister Yariv Levin and Simcha Rothman, the member of Knesset. Look, the override is a wonderful place to start, and I think there are sort of reasons to object. I'll give a little overview of what exactly we're talking about. The idea of an override clause, or what I like to call it as a right to insist, is what happens when a court invalidates a law, meaning strikes down a law as unconstitutional. The idea of an override clause is that the parliament, in some way or other, has the ability to insist on that law being still in force, so to speak. Even though, or notwithstanding, right, even though the court has struck it down, or sometimes even prospectively in advance, saying that the law will remain in force, even if the court were to declare that it's unconstitutional. So there's a lot of confusion about this, and that's already worth sort of clarifying. We're talking about the world of striking down primary legislation. We're not talking about administrative judicial review and all the sort of all those other spheres of law which end up getting mixed up with this. Obviously, there's a huge amount to say about this, but I think that the override clause in Israel, in some senses, is a wrong place to start. And what I mean by that is, of course, I want to talk about the override clause in Israel, but the real anomaly here is, as Sam, I think you started describing well, is the fact that we have judicial override, meaning the first level of override is judicial override of legislation. That's sort of the first stage of override. In Israel, we have, since 1995, we have judicial override of primary legislation. Now, that's something that's not unfamiliar to many people around the world, certainly not to Canada. It's obviously less familiar in the UK, where, except for some exceptions, generally you don't have judicial override of legislation. The anomaly of Israel is that we are the only country in the world where the court can strike down laws without a written constitution, without a codified, conventional, established constitution, in the sense that usually people are talking about when they use the word constitution. And Israel, in this sense, is a complete anomaly. This is an anomaly created by the court, caused by the court, brought around by the court, and for which the court is responsible. And when we talk about the override clause in Israel, in many senses, what we're talking about is a sort of inelegant, unattractive, and even blunt method of coping with this fairly bizarre situation in which the court can strike down laws without any constitutional basis, without any fundamental idea of what a constitution is. And I want to turn over to Professor Alford in just 1 minute, but I think it's worth sort of elaborating on this just for a second, even with a real world example. So, of course, there are many examples of the court in Israel striking down legislation, but one of the sort of more well-known ones are the numerous times where the court has struck down legislation relating to the military draft exemption for ultra-Orthodox men. Now, I should say, I serve in the military. I've served I'm a combat soldier. I still serve in the reserves. And my opinion about whether ultra-Orthodox men should be exempted from military service is immaterial to the matter at hand. The point is that the court intervened with a specific question, with legislation, struck down legislation about whether ultra-Orthodox men would be exempt from military service. This is legislation that was a compromise, a major sort of political compromise between different factions. It was a benefit conferred to a minority, so there's no issue here, protecting minority rights. There was no issue here protecting particular human rights or anything like that. This was pure court intervention in a purely political issue. And the reason I'm giving this example is because after the court struck this down twice, again, without any constitutional basis, I won't go into the intricacies, but the court basically invented an unenumerated right, which isn't even textually based in the basic laws, meaning, and this is something which has been criticized by the legal left as well as the legal right. So the court strikes down legislation based on unenumerated rights explicitly excluded from the basic law, meaning deliberately not included, removed from previous drafts and when this law was legislated. What is the electorate to do? What are the people to do? What are the representatives to do? So in a moment, we'll hear about Canada, and I think that an override clause is a sort of cumbersome and slightly peculiar method, and there's a minority of countries in the world which employ a mechanism like an override clause. But in Israel, the question should be the opposite. It's unthinkable that we shouldn't have an override clause. It's unthinkable that the court can strike down primary legislation, like the example that I gave, and there are many others which are pure policy questions, value questions, questions of priorities, etc. It's unthinkable that the court can strike down these laws without leaving the people, the electorate, and their representatives any recourse or any kind of mechanism in which to give them the ability to insist. I'll stop for now.
Let me just go to Ryan, if you don't mind. Ryan and Caroline, I'm going to ask you if you could put up the PDF I sent you on section 33 of our own charter. So Professor Alford, or Ryan, if I may, is the ability for the Parliament to override a decision by the court, the striking down legislation, is that something foreign to Canada? And I sort of know a little bit about what your view is. Do you think it's a good idea and actually furthers democracy? And just before you go there, I have to say to the people watching that you can put your questions in the Q&A section, and I see them and I'll try and get to them. We're going to try and reserve maybe 10 or 15 minutes for questions and answers. So Ryan, here's the section 33.
That's great, Sam, and I appreciate that. I'd say that one of the things that I like to start by mentioning is that Section 33 is not outside of our Bill of Rights. So in 1982, Canada received for the first time entrenched rights. And part of this bargain that was struck at the time was that in adapting this notion of the Bill of Rights that allows for constitutional review, that we were going to adopt a via media with respect to parliamentary sovereignty by including precisely this clause. So it's not outside of the charter. It could have been put in the constitutional document that served as the envelope for the charter, which is to say the Constitution Act 1982. The decision was to put it directly inside the charter. So this is thought to be exceptional, and I think it is indeed exceptional, but in the spheres of comparative constitutional law, Canada's constitution was enthusiastically championed by a number of scholars across the globe for achieving precisely this, for putting into the schema of a Westminster system a Bill of Rights, but one that nevertheless allows for the preservation of democratic legitimacy through a parliamentary override. And just a couple of other points I'd like to...
Sorry, Ryan. Carolyn, you can take it down now. Thank you. Go on, Ryan. Sorry.
Just a couple of things I'd like to mention to build on what Yonatan said. It's also very powerful. So what's being proposed in Israel right now is something that would say, okay, well, if we have a decision by the court, then there'll be an override by Parliament. What Canada has is far more powerful insofar as what Parliament does is they say in the text of the instrument, this will not be subject to constitutional review. And when they do that, the majority position of Canadian scholars is the court can't even talk about it. It's just purely outside of the jurisdiction of the courts. And it's not just with respect to certain minor areas of the Constitution, although since it's had such a calming effect, a restraining effect on the Canadian judiciary, which bears mentioning, it's only been used in a number of areas, particularly with respect to language rights and having to do with labor rights. But it does pertain to fundamental freedoms, and it also does pertain to the right to life, liberty, and security of the person. So on a number of occasions, Canadian legislatures have said this legislation, which may or may not offend against fundamental freedoms or the right to life, liberty, and security of the person, is entirely outside of the constitutional review jurisdiction of the courts. That's very powerful. And I would just say that there's really been no pushback internationally as to this being somehow exceptional or contrary to the notion of constitutional review, because we were departing from a norm that was unbridled parliamentary sovereignty.
So Ryan, just to follow up on that, how is the notwithstanding clause, although many people see it as something anti-democratic, so recently the province of Quebec has invoked it to protect its French minority rights. Ontario, the province that we live in, has threatened to use it. But you see actually the use of the notwithstanding clause is actually good for democracy, and particularly with respect to federalism in Canada, although Israel is a single state.
Well, the problem we have is the controversies in Canada always come up with the use of the clause. And then you can debate whether or not it's appropriate in a particular circumstance. But what I would say is this: the existence of the clause is very positive. And everyone's thought that. We have this theory in Canada of what's called constitutional dialogue. How do we get to a position of constitutional supremacy, right? Where we don't have a system where the parliament is the one that has the exclusive view as to what's constitutional, without creating a system where an unelected judiciary, effectively Platonic guardians, saying that this is, the Constitution because they have the final say. So instead of having that kind of a system, the only way that we can really have constitutional supremacy is to have this back and forth between the legislature and the courts about the boundaries of rights. And that's not abnormal in the Canadian system. I would just note that in addition to Section 33, we have Section 1. So every right that's embedded into the Canadian Constitution is subject to both legislative limitation pursuant to Section 1. And again, this is a priori, right? It's before the legislation is subject to judicial review, and also to derogation under Section 33. Just to follow on one last point that Yonatan made, which I think is a very good one. When you have in Canada people asserting that there are unenumerated rights, what we typically call unwritten constitutional principles, and that this should be the basis for the Supreme Court of Canada striking down legislation, that has been particularly controversial. And our Supreme Court to date has rejected it in every single instance in which it's raised, despite the fact that the legal profession brings that question to it again and again and again, for obvious reasons.
So Yonatan, just before we go on to another topic though, this is a situation I've always thought about with what's going on in Israel now, is really it's sort of liberalism versus democracy, in that if Israel's going to be a democratic state, if it's going to be a Jewish state, it has to be a democratic state. It has to be able to fully express the desires of the Jewish people. If it's going to be a liberal state, that means it's really importing the concept of modernity, and it will affect the Jewish character and nature of the state itself. Do you think that's a little bit going on here in terms of the controversy happening in Israel now? Liberalism versus democracy, Judaism versus modernity?
Sure, Sam. I think that's one element, or at least it's perceived in that way. I do want to respond to some of the things that Professor Alford has said, but just about what you're saying, Sam, I think that works on two levels. One is that, I would say that both I and sort of people like myself don't see any kind of tension or any kind of any kind of disagreement between the democratic and Jewish character of Israel. Israel has a Jewish majority, and they go to the voting booth, and they elect their representatives, and the representatives enact sort of Israel's sort of national Jewish identity. And I don't think that's sort of different from other democratic nation states in the world. Certainly, of course, there are questions of church and state in Israel, which complicate things. And obviously Israel's Jewish character, Jewish national character versus its Jewish religious character is something which is quite complicated to untangle, even if possible at all. But certainly, to put it slightly differently, I think that many people see it that way. Certainly the sort of more protesting movement on the left, there are those who we can be more cynical about and who simply just want to bring down a right-wing government and just don't like the idea of the right wielding certain powers and making certain changes. But there are others who are sort of genuinely concerned about the idea of having a right-wing government with a major ultra-Orthodox element to it, making these extremely important and fundamental decisions for the country. And the one last point I'll make there is that I think it's without question, you can say that the main beneficiaries of judicial overreach in Israel over the past 4 decades have been the political left. And this is something that also critics on the left have said, not only on the right, that the political left has essentially abandoned electoral politics in favor of politics through litigation, politics through the bench, and enacting their preferred policies through a highly activist and highly powerful court. And in this sense, that court has been sort of championing certain liberal values or liberal ideas at the expense of the democratic and the political process. Putting that aside for a moment, I do just want to quickly respond to some of the things that Professor Alford said. I think I really appreciate the points that Professor Alford said, especially about sort of the idea that the notwithstanding clause, this override concept, is not some insane foreign concept, even though it's not used so much around the world. It's lauded in Canada as a very successful type of constitutional dialogue between this idea of parliamentary sovereignty and the democratic process and this idea of entrenched rights in a constitution. And I think one of the challenges here is that, many times people, those that oppose the reforms in Israel often point out how Israel is different from Canada, in the sense that, in Canada, we're talking about a federal government and there are, constitutional entrenched rights, et cetera. But I think I want to point out the differences from the other direction, meaning in Canada, when we're talking about constitutional dialogue, we're talking about a court that has been explicitly enabled, meaning the court has been explicitly authorized to strike down legislation. We're talking about a constitution where nobody doubts, the process that brought into being the constitution. Nobody doubts the existence of the constitution. In Israel, we're in an entirely different universe. And I absolutely agree with everything that Professor Alford said. But I'm adding to that, in Hebrew, we say, kal vachomer, if that's the case there, then of course it should be the case in Israel, where there is no written constitution. There is no constitution that was ever accepted by the population. And that's still a point of contention about whether Israel even has any kind of constitution to speak of. Then of course it's unthinkable that you have this kind of judicial supremacy where the court is the final arbiter on public issues. And here I'll just insert the sort of UK or British perspective. In many senses, the real point of comparison here is the UK. Israel until 1995 was a regular run-of-the-mill parliamentary Westminster style democracy with parliamentary sovereignty. Period. There might have been a few sort of asterisks or caveats or exceptions, but generally speaking, that was the rule. And that's what the court radically changed in 1995, unilaterally, without public support, without public debate. And this whole anomaly, whenever we talk about this idea of an override clause in Israel, and I do think that there are reasons to find it objectionable. I think people do have valid concerns about the idea of the Knesset overriding judicial decisions. However, we're much more similar to the UK. And if you can imagine the UK Supreme Court coming to Parliament and saying, we are striking down your legislation based on an invented constitution which never existed, and then the Parliament coming sort of back to the court and saying, well, hang on, if you're going to do that, then we need some kind of mechanism to override you, because we don't even have a constitution. We don't even have the mechanism to define your boundaries and your limitations. Sorry, that was a very long answer. We can move on.
So let me go to Ryan now for the second question, because one of the next issue, which leads, I think, leads from that discussion about now the judges are going to be able to tell Parliament what to do, makes who selects the judges very important. And as I understand it, in Israel, there's a committee by convention that decides the judges, but the committee, the majority of people on that committee are actually judges and lawyers, in other words, non-elected people. What's the situation in Canada, Ryan?
Just wanted to say, there's so many interesting points coming up here. This notion that there's a restraint on the judiciary, it really does depoliticize the judicial appointment process. If you have a system where it's completely open-ended, where you're effectively telling people the way to achieve political change is through the judiciary, and wherever this exists, I might gesture in the direction of the United States, it's an extremely dysfunctional dynamic. We've avoided that in Canada, but I don't think it's strictly because of the appointment processes themselves. Because you look at the appointment processes and you say, well, they're subject to a tremendous amount of political manipulation. I mean, the notion, when a Supreme Court justice in Canada is nominated, it's frequently on the basis of close connections to the ruling party, or at least that's what people would say. Why hasn't that been problematic? It's been because the legal system and the judiciary understands their role in a particular way. And when they're appointed, they operate within that role. And so we've had a number of situations where justices appointed relatively recently, I would say Malcolm Rowe is an example, that people expect them to rule in a particular way with respect to the positions of the existing government. And they don't. It's because they don't see themselves doing that, and they're held accountable via a community that has maintained a very traditional view of what they're supposed to be doing with respect to the protection of rights. And I would just say it is remarkable when you point out and you say, look at the power that these judges might have with respect to unwritten constitutional principles, or with respect to just principles that work themselves into the jurisprudence and then are brought to the court's attention, particularly by activists. What you need is somebody who has that restraint. It's not going to come out of a process that examines these people. The process in the United States, the judges come out and they perform a very ritual performance where they disclaim any position on any of the prevailing issues at the time, almost to the point of saying, what's abortion? I've never considered that issue before in my life. And it's thoroughly unconvincing. But nevertheless, we've been very successful, despite the fact that this is very open-ended, very subject to just the control of the cabinet, as you normally have in a Westminster system. But it's because our culture is one of judicial restraint.
But in Canada, Ryan, the politicians do select the judges.
They absolutely do, but they're forced to select judges from the legal profession. And insofar as the legal profession hasn't been completely, and I say completely because this, of course, is a dynamic that we're dealing with, adapted to this notion that the legal profession is about achieving social change, rather than, let's just say, helping people to adjudicate private disputes, you're going to have people who have had esteem in that profession because their ability to perform the role successfully. And so insofar as the culture of law has not entirely become one of activism, and completely identified with what people call the professional managerial class, but rather with the population as a whole, you're not going to have the kind of problems come up just because it's politicians who choose, because they have to choose from the flower of the bar or else lose considerable esteem.
Ryan, I must take issue with you on this, because you're making it out to be much more Pollyannish than I think I'd like to leave people watching believe, because and we should point out that there are federally appointed judges and provincially appointed judges. And on both levels, there is some sort of committee which then vets applications and then sends them on to either the Minister of Justice federally or the Prime Minister, who the Prime Minister selects the actual Supreme Court judges. The Minister of Justice selects the courts of appeal for the provinces and what we call, I think what the British would call Queen's Bench or King's Bench levels of court. But on the provincial court, there is a judicial advisory committee, and that judicial advisory committee, the civil society legal organizations are becoming taken over by, I'll be kind to say, progressive left-wing forces, and those progressive left-wing forces are then simply sending up nominations to be judges of their own political leaning. So I think
it's quite paradoxical. If I could just leap in there, Sam, it's really paradoxical, because the higher and more influential the justices, the less involvement we have from these para-civil society organizations that tend to be the most amenable to capture by organizations with clear political agendas. So it's that itself is paradoxical. But then the really paradoxical result is the more professionalization we have of judicial appointments, the more the appointees are not professional, but rather are outside of that traditional role of the lawyer and more likely to be associated with activist causes. So people saying the way that you prevent the politicization is to have this purportedly apolitical process, purportedly run by the profession itself. What Sam points to in Canada is clearly a cautionary tale.
Well, I'm going to go back to Yonatan, and I just still on this issue of selection of judges. In Israel, again, I think the issue there is the fact that you have a self-selection and of the judges, because it's the majority on that committee who are within the legal community. Now, Ryan's position seems to be that that's okay, at least in Canada, because there's still some sort of adherence or ostensive adherence to professionalization. But the concern in Israel is that you're just getting a self-perpetuation of whatever the legal views are, And it's important to have a political influence in the selection of judges because, every election, there's sort of a cultural change in terms of the electorate. And the only way, to some extent, the politicians, when they're elected, can make sure that their laws are being enacted is if they, again, choose some sort of political, or let me rephrase that, judges who at least share some sort of political values as they do. Can you comment on that, Yonatan?
Well, absolutely. And I think also Professor Alford has made some really interesting points and insights on this. Look, first of all, just to describe to our audience exactly what happens in Israel, it's a statutory committee. It's not a committee by convention. It's a 9-member committee, 3 of which are presiding judges, sitting judges of the Israeli Supreme Court who choose their colleagues or successors, 2 of which are members of the bar. So that's 5 out of 9. Already a majority member representatives of the Statutory Bar Association, and then 4 are elected representatives, 2 from the Knesset, from the parliament, 2 from the government, from the cabinet. By convention, but not always, one of the members of the Knesset is an opposition party member, but not always. It used to be you needed a simple majority to appoint judges, and judges were being appointed without any involvement from public, from elected representatives. You had a 5-person majority from the legal establishment, so to speak. And I don't need to explain to you why there were many reasons for the Bar Association and the judiciary to cooperate, and they had many sort of shared interests, et cetera. And many times they would sort of go sort of in the teeth of whatever the political establishment wanted. Eventually, this was amended in 2007, I think. It was changed that for the Supreme Court specifically, you need a 7-member majority, so 7 out of 9. The problem was, even though this gave the politicians, so to speak, a veto, it still maintained a judicial veto. And to this day, the judges still do maintain a veto about who joins them on the bench on the Supreme Court. Now, going back to Canada just for a moment, forgetting, we'll get back to Israel in a second. If we put aside the nuances, ultimately Canada, I think, reflects a global understanding that the more powerful judges are, generally speaking, the more powerful a court is, the greater authority it has, and especially if it's a constitutional court, especially if it has the power to strike down legislation, then the appointments process is more political, and there's more, and it reflects greater, whether you want to call it, reflects the elections returns over time. It reflects the sort of prevailing elections moods. It reflects the winners of the elections and the majority in parliament, etc. That is a fundamental understanding shared by almost all democracies in the world. And in this sense, Israel moving to a more political system of appointing judges is a natural move, considering the massive expansion of power that the court has had. And again, this is something that was foreseen by all the critics of the court in the 1990s, meaning whether it was former Chief Justice Moshe Landau, whether it was Professor Ruth Gabizon or Professor Yoav Dotan, everybody across the board said, look, guys, if the court is arrogating to itself more and more powers that it was never explicitly authorized to do, then people will start asking to change the political appointments process. Because whether you buy the idea, or whether you buy into the idea or not, that this is some kind of depoliticized or professional process or whatever it is, people will simply not accept that if a court can strike down laws, then they can also select their own successors, and the politicians cannot have final say and should not be heavily involved in that selections process, because these are judges making political decisions. And this has to do back to sort of what Professor Alford was saying. It's this idea, there's this myth of the professional or the depoliticized appointments process. And I mean, in Israel, it's absolutely a complete myth. We've seen many examples where that just hasn't been the case, and I'll touch upon that in just one second. But also the decisions themselves, meaning ultimately we see more and more situations where courts are making political, value-based decisions which cannot be characterized as judicial in any way. And I'll just say that always brings to mind the quote from Justice Antonin Scalia in the US, where he says, in matters such as these, there's no difference between 9 judges on the bench and 9 people selected at random from the Kansas City phone book. And so many of the court's decisions are in that category. Sorry, Sam, one last point that I do want to make here, bringing us out of the world of comparative and theoretical law and et cetera, down to the real world. This might not have been an issue if the Supreme Court in Israel had not abused its power and not abused its veto in the selections committee in such aggressive ways as it had over the years, where the Supreme Court has blocked extremely competent and capable and some of the top and best jurists in the country. The classic examples are Professor Ruth Gabizon or Professor Nili Cohen, where the court has blocked these candidates for purely ideological reasons, having nothing to do with their professional capabilities, having nothing to do with their competency as judges. It was purely because they were critical of the judicial activism and they envisioned a more limited and restrained role for the judiciary, and they were blocked from coming to the court. If that had not been the case, I imagine that the demand for changing the judiciary, for changing the judicial appointments process, even considering the court's enormous powers, we would not be seeing the same demand.
Just, I'm going to go to Ryan in just one moment, and we'll I see your hands up, but Ryan, we're going to go to you anyways. You don't have to raise your hand. But just picking up from what you're saying there, I do note, and correct me if I'm wrong, Yonatan, but there's never been a Mizrahi Israeli being appointed to the Supreme Court. I seem to remember one Israeli Supreme Court very early on in the history of Israel saying that there wasn't one worthwhile Mizrahi lawyer to be appointed to the Supreme Court. And in the 75 years since, there hasn't been a Mizrahi appointment to the Supreme Court. In Canada, one thing about a political figure being in charge of the appointments, at least it allows that sort of balance. One of the issues in the Supreme Court that it used to be so it still is an issue in terms of the balance across the provinces. Each province, convention-wise, is supposed to have X number of Supreme Court justices. Recently, we've had the first appointment of a Canadian Indian or Aboriginal First Nations or Indigenous person, this woman, Obitswan, who is appointed in some sort of recognition of that. We also have our first Ismaili Muslim who was appointed, and that's the benefit of having a political process, is it could be sensitive to when society wants that sort of ethnicity to be reflected in the Supreme Court. I'm going to go away from you, Yonatan. Sorry, Ryan. I know
before you ask, can I just respond directly to Yonatan?
Yeah, sure. Yeah, that's what I want.
So I just want to say that it's really remarkable when people are talking about how the Canada's notwithstanding clause really isn't a good marker for what's happening in Israel right now. Something they frequently say is it's never been used by the federal government of Canada within our federal system, but merely by provincial legislatures. Well, that's not, that may be accurate, but it may not be accurate for long, because in our last election, this was an issue, but then in the run-up to the selection for the leader of the opposition, so Canada's Conservative Party sits in opposition now, they had a leadership race. All of the candidates in that leadership race indicated that they would use the federal notwithstanding clause in certain circumstances. And then those circumstances very soon afterwards came to pass in a case called Bizinet. So in Bizinet, the Supreme Court of Canada said that it's cruel and unusual punishment to sentence someone to life imprisonment without the possibility of parole. Actually, more than that, because we already have the possibility of parole through what's called the faint hope clause. And the applicant in that case was a mass murderer who had committed mass murder at a Quebec mosque. And that person was told by the Supreme Court of Canada that you have to be resentenced because that is cruel and unusual punishment. That is precisely what would bring about the federal use of the notwithstanding clause. So you ask yourself, why is there a need for this override? It's because in certain circumstances, you see a court which says, well, we don't want to be sidelined. We have a clear institutional interest in expanding our own powers. And if they don't think that there's an institution ready to come by and say, well, you're expanding the boundaries of your powers beyond our constitutional design, they will always continue to do so. Nature just abhors a vacuum. So I think that particular point of distinction, which is frequently drawn by Canadian lawyers in discussing Israel, it's not as trenchant as they think it might be.
So let's go to the third point here. And I think
Sam, can I just make one quick comment to Professor Alford, super quick, and also just to respond in half a sentence to one thing you said. I won't elaborate on the whole question of Mizrahi representation on the Supreme Court, which is extremely important and really a point of contention. I will just say that there have been occasional Mizrahi representatives on the Supreme Court. There's one now. There have been a few over the years. And I won't go into that. I think that's certainly not remotely representative in terms of their proportion in society. But I'm of the opinion that, let the political process work its magic, sort of somewhat in the way that you described, and let the politicians appoint the people who they think, most competent, but also conceivably most representative of Israeli society and Israeli values and whatever it is. And there's no doubt in my mind that we would find many more Mizrahi candidates and more Mizrahi representatives on the court, or more Mizrahi judges on the court. There's one comment that I forgot to make to Professor Alford, which is such an interesting insight that I thought that he made, which was about the interplay between the notwithstanding clause and the political appointments process. Because essentially, one of the things that he's saying is that there's a sort of game that's played between them, and often in Israel, one of the claims that comes up is that one of the terrible things about the proposed reforms is that it brings up all these together. It's sort of, well, you can have a political appointments process, but not a notwithstanding clause, or vice versa, right? You can have a notwithstanding clause, but not a political appointments process. What Professor Alford is saying here, these two mechanisms temper each other in many senses. And if you have a notwithstanding clause, politicians know that they don't actually have to appoint judges who are going to do exactly what they say. They don't have to appoint judges who they can predict exactly how they're going to rule in every situation, because they have a fail-safe mechanism. And of course, vice versa, they might be way more hesitant in the way that they use the notwithstanding clause, because the judges enjoy a certain kind of political legitimacy in the decisions that they make. The judges might be much more hesitant in the way that they use their judicial review because of the notwithstanding clause. So you have all these effects where everybody is tempering everybody, and that's a positive thing. And I think that's something that's completely lost in Israeli discourse around this issue. So Professor Alford might want to add something, but otherwise,
Well, let me.
No, I think that's exactly right. Just the more checks and balances you have in a system, the more that everyone stays in their lane. And I don't understand why people think that courts somehow are different and that they can be trusted to be considered as depoliticized actors when we constantly incentivize them to act in political ways.
So Ryan, let's start. Let's keep with you. And a lot of our discussion with respect to notwithstanding clause and the selection, this issue has come up tangentially in what both of you have been saying, and that is the judiciability of certain issues. And you, Ryan, have talked about, you sort of alluded to it. We were talking about in Canada, we have these unwritten constitutional values, and Yonatan, you also talked about that sort of same thing. It seems to me that when courts don't like a law, but they can't find anything specific to turn it, to strike it down, it appeals to some sort of esoteric values that none of us can see except them, and sort of some sort of Gnosticism of some sort. How does that work in Canada? Do we have that problem?
I would just say that it's really difficult for people to see all of the restraints that exist on the judiciary if they don't have a really good understanding of the constitutional system as a whole. And Canada's is very complicated. So we don't actually have a purely written constitution. We have what's called a mixed constitution. It has an open texture, so we have partially written and partially unwritten. And then when you think about what the judiciary can do with respect to reviewing legislation, it's actually a lot more complicated than it initially appears because of all these things that exist, like conventions, right, unwritten constitutional principles, and then also all of these doctrines that have emerged in the common law tradition to kind of counsel judges to reject certain types of cases just purely out of prudence. They might in fact have some sort of de jure jurisdiction over particular issues, but they consistently decline to exercise it because they understand that doing so undercuts their political legitimacy. Now, in the United States, they have like one doctrine that encapsulates most of this, which they call the political question doctrine. So in the United States, where the Supreme Court is very strong, you have absolute guarantees in its Bill of Rights. Nevertheless, the judiciary just says that is a political question. We will not adjudicate it. Canada doesn't have a political question doctrine, but we have a number of other doctrines that kind of form one out of a mosaic of different things, right? So we have instances where, for instance, the court will say, well, that's parliamentary privilege. That's a debate within branches of government. Don't expect us to adjudicate it. And it's really great because you see a situation where, again, its jurisdiction just remains such that there are fewer incentives to attempt to politicize it. And it's remarkable how long that's continued. I think it has to do with the prestige over time of these elements of a Westminster system is something which is very hard to build up. But again, just to understand all of these restraints, it takes a lot of knowledge about how this common law tradition works and how Westminster systems work with their conventions, et cetera. They may not be initially apparent, but just saying, okay, with respect to a Supreme Court like the United States, well, look, they'll just consider any issue. They'll involve themselves in any kind of political dispute. It's just simply not true.
But Ryan, we still in Canada, often the Supreme Court will read in to the into legislation. The famous case of Brith from Alberta, that was a case where as a gay man who wanted to teach in the Catholic Church. He tried to argue that it discriminated against him, and the Supreme Court, although being gay is not a specific prohibited grounds of discrimination within Section 15 of the Charter, nevertheless, the Supreme Court read it in, although Parliament didn't explicitly put that in. Whether you're in favor or not in favor of gay rights is not the issue. The point is there the Supreme Court found it, although it wasn't written in. So a little pushback to you that, in fact, our Supreme Court does decide what the law should be.
Oh yeah, and you shouldn't be surprised because there's just so much incentive for them to do it. But what we're talking about for the most part is the expanding of boundaries of existing rights. So within civil rights law, we've recognized, this is a minority, it shouldn't be treated in particular ways. And then the Supreme Court, so an example people might be familiar with in the United States, recently a case called Bostock, where they said for the purposes of civil rights, transgender people are being treated in the same manner as gay and lesbian people, right? Mm-hmm. Very controversial, but the Supreme Court of the United States and the Canadian Supreme Court often feel that they have the latitude to do this because there's a broad consensus in society that the right is important. And then when they go and they do things like invent rights out of whole cloth or try to reconfigure the relationship between the branches of government, right? They're doing something without that kind of consensus. And they're really going to damage their political legitimacy in various ways. And the court remains sensitive to that. So I would just say in Canada, you look at how they expand out an existing right, particularly ones related to minorities, related to civil rights. They do that to the plaudits of the Canadian populace as a whole. When they do things like recognize the power of the court to strike down legislation on the basis of unwritten constitutional principles, they rejected that poison chalice in Toronto and Ontario.
So what about Israel? Is there the same sort of hesitancy to engage in what is purely what we would say in Canada should be political decisions?
Well, for many years, Israel did have some kind of political question doctrine where the court refused to engage in purely political questions. This was both with the administrative branch, and also this was one of the main reasons that the court didn't strike down legislation for so many years and refused to do so, not only on the sort of technical reason that the court wasn't authorized to do so, but also because it wasn't wise and it would be extremely imprudent and essentially damaging and destructive to the court to get involved with those things. But unfortunately, that has been done away with completely by the court since the 1980s and 90s, and it's actually just been deteriorating since. And I'll give you an example. I mean, the sort of easy examples which have nothing to do with striking down legislation is the court dictating to the prime minister whether and which cabinet ministers he or she has to fire. This has been going on for years, since the early 90s, since the Derry case of 1993, where the court said that an indicted prime minister had to be fired, an indicted minister, a cabinet member, had to be fired by the prime minister, even though the black letter law clearly did not require it. And this was I'm not going to go into the sort of nuances. This is based on the reasonableness doctrine, et cetera. But regardless of this sort of technical legal doctrine, most courts around the world would have rejected any kind of claim to do this, because they would have said the question of whether you fire or hire a cabinet minister is a purely political question within the political realm. So that's just sort of one kind of example. I think there are very few countries in the world so very few courts around the world which would mandate that the executive fire or hire certain members of cabinet without sort of strong statutory grounds. But I think your initial question about unenumerated rights and sort of Professor Alford's elaboration on that is important. I do want to make the distinction again. The question of unenumerated rights or unwritten constitutional principles, et cetera, which are sort of judicially enforceable, those are questions which have their own legitimate space, and there are situations, I think, where when it's absolutely right for the court to sort of get involved in certain circumstances. Those belong to the arena, to the world of some kind of written constitution. from which you can understand some basic principles or some unwritten core constitutional values or whatever it is. Meaning the notion that you can use unenumerated rights from an unwritten constitution to invalidate legislation is completely alien. And this brings me back again to the UK or to New Zealand, meaning Westminster-style parliamentary democracies without a written constitution, with parliamentary sovereignties. In these places, the idea that a court could strike down a law based on some theoretical principle is completely alien. And I do want to, for our UK audience, I do want to clarify one thing which Natasha mentioned to me, and I think is worth saying. Many people in the UK often in this kind of context bring up the prorogation case, or the two Miller cases surrounding Brexit. And those are cases in which the court sort of got involved with a highly sort of sensitive political question. The grounds were much closer to sort of unenumerated principles of parliamentary sovereignty, and not sort of grounded in any sort of specific statutory or textual basis or whatever. And I think that's the distinction there, the critical distinction that people often miss, is that in the Miller cases in the UK, the court was enforcing parliamentary sovereignty. It was on the side of parliament, meaning it was reviewing. And even though I think that there's a good case to be made that those were erroneously decided, but even if you agree with those cases, that was review of administrative executive action, not of parliamentary action. And it was there to defend the notion of parliamentary sovereignty, which is the one core unwritten principle of UK jurisprudence above all principles of that system of government. And the last thing I'm going to say here is, if we're already talking about judiciable questions and sort of what is the purview of the court or not, there's one thing that everybody at least should in theory agree, which the court is never supposed to get involved in. And that is the very definition of what the court's powers are and what are the boundaries between the court and the legislature, et cetera. And what I mean is, I'm not talking about a constitutional amendment in a sort of typical sense, but when we're asking these questions, right? Is it right for the court to do this, or is it right for the court to do that? If a parliamentary majority comes along and says, and again, without a written constitution, so we're in a system of parliamentary sovereignty, a parliamentary majority comes and says, we are enacting our highest form of law that we know. In Israel, that's called the basic law. We are sort of enacting the highest level of law in our sort of normative hierarchy. And we are saying, this is how judges are going to be selected, or this is how legislation is going to be struck down. Surely that should not be justiciable, meaning surely the court cannot come along and say, actually, this goes against, fundamental principles of democracy, or this goes against fundamental principles of the rule of law, and therefore I will strike down the very laws which are supposed to govern how the court make decisions. And that's, I think, the biggest problem that we're seeing right now, and that's the biggest deterioration. Over the past 5 years, we've seen a new willingness, something that would have been unthinkable 10 or 15 years ago, a new willingness by the Supreme Court to review the legality of basic laws, which are as close as you come to constitutional amendments in Israel, meaning the court decided the basic laws are the Israeli constitution, and the court decided that it can invalidate laws when they violate a principle or a rule in basic laws. And now the court in the last few years has been coming along and saying, no, we can actually review the legality of basic laws. And I think this is something which should be considered completely unthinkable.
Let me, Ryan, just before I get to you, I just want to, because a couple of our people out there who have been watching this have asked sort of the same question, which is going to you, Yonatan. Can you just, we have maybe 7 more minutes left. Can you explain why the Declaration of Independence is not the Israeli Constitution? When I say the Constitution, I'm thinking in terms of the American context and the Canadian context. Can you explain that?
So, I think I do want to hear Professor Alford. So I will say in half a sentence, since the founding of the state, the court has summarily and consistently rejected the idea that the Declaration of Independence can form any kind of basis as a constitution for Israel. By the way, for the same reason that the Declaration of Independence in the US is not a constitution. And there's some discussion in the US about whether it has some kind of statutory or interpretive, weight or whatever it is. But the Israeli Declaration of Independence is a declaration. It wasn't meant to serve as a constitution. Nobody considered it to be a constitution. The courts and society and the political class all rejected the idea that it might be a constitution. I will send in the chat box a link to a wonderful article written by yours truly about why in Mosaic magazine of the Tikva Fund, about why Israel, why the Declaration of Independence is not and cannot be considered the Israeli Constitution. But I do want to hear Professor Alford's comments on what I said before.
Oh, just briefly on Miller too. This is really important. So in Canada, when we saw Miller 2 decided, every Canadian academic would say, well, there's no way the Canadian judiciary would have touched that, right? So we had a similar prorogation crisis about 10 years ago, and no one had anticipated that judicial review would have worked there. But I would say this, even in the United Kingdom, where it seems like the Supreme Court of the United Kingdom is having recourse to what we would call unwritten constitutional principles, they're located in a repository of constitutional instruments to some degree, right? So we're talking about the relationship between the executive and parliament, cabinet and the two houses of parliament. Well, okay, so we have instruments like the Bill of Rights 1688, the Act of Settlement, the Triennial Act and the Septennial Act. This is giving us an indication of how these concepts are to be treated. So at least there is some sort of textual basis there, right? So it's not completely unmoored. You can point back, and the United Kingdom can do this in a way that Canada can't, because those issues, like for instance, what we would call responsible government, the responsibility of the cabinet continuously to parliament, are the result of a struggle that yielded instruments. And whether we call those statutes or we call those instruments of constitutional significance, the way that Lord Laws did in Thilborn and Sunderland City Council, is immaterial. It's still a textual basis for saying that this is the nature of the constitutional architecture. So what you're talking about with respect to a much younger legal system like Canada's or perhaps Israel's, where instead of looking back and saying, can we intuit things from these very important texts in our constitutional tradition, but rather doing it by virtue of reference to some sort of an ideal, however subjective, it's just so much more dangerous.
You want to comment on that, Yonatan, at all?
I mean, obviously there's a lot to say, but I think there's excellent points, and I do want to allow a few more minutes to hear questions from the audience. I know that there have been a bunch piling up.
Okay, so we've asked that one person asked, do British courts have doctrines that deny courts the power to rule if one, the plaintiff has no standing in the sense that suffers no personal injury, and two, the legal issue is not judiciable because it is, for various policy reasons, not subject to judicial decision, like a political question. Now, we've talked a little bit about that, but I think the key to this question is the issue of standing. And that was also being, maybe in the last few minutes we have here, we could talk about the issue of standing and what that means. So, Yonatan, what's going on?
I see Professor Alford wanted to say, I'll let you go first, and then I'll touch upon that.
No, hopefully I'll just be setting up Yonatan's comments, but I would say the issue of whether or not the court departs from these classic doctrines of standing, which are common law doctrines, they came to Canada from the United States, is a clear indication of how activist the court is and how it wants to intervene more actively in what are political questions. So when you have a doctrine, we call that in Canada public interest standing, which is a departure from that basic principle. And when you get into these doctrines that allow organizations to bring these cases in which they even have a financial interest, which cuts against principles of long duration in the common law called champetry and maintenance. And that's probably too in the weeds, but the notion is you shouldn't be bringing court cases and funding them because you hope to have some sort of financial benefit through fundraising, let's say on the back end. The more that the courts encourage this, the more you have this problem of politicization. So the more that you see courts invoking standing to keep people out of the courts, the more you know that they're kind of still not entirely captured by that mentality.
Yonatan?
Well, of course, the question of standing and judicial question are deeply related, right? Because more often than not, if you were actually to keep to the standing rules in their sort of more common traditional sense, then many purely political issues wouldn't even be raised. They wouldn't be sort of conceivable for adjudication because there'd be no plaintiff. I mean, and the example I gave before of the Arya Dairy and the question of does the prime minister have to fire a particular cabinet minister or not? Who's the plaintiff? Who's the aggrieved party who's supposed to come along and say, I demand a remedy from the court in my personal grievance? So absolutely, what I would say about Israel is that the standing doctrine, along with the justiciability doctrine, have been totally annihilated by the court over the past 30 years. One of the greatest example that we have is that very recently, during these sort of opening months of the war with Russia, between Russia and Ukraine, there was, I should say, the Russian war on against Ukraine. Israel was formulating a sort of a refugee policy for Ukrainian refugees. There were quite a lot of Ukrainians who were sort of applying for asylum or for applying for visas to come into Israel. And you have a minister of the interior who this is a pure policy decision. There weren't any specific sort of statutory or constitutional issues in question, which whatever it was. And a lawyer brought a suit. Personally, he has no relation to anybody. An Israeli lawyer brought a suit against the Minister of Interior for her policy on this particular issue. He brought it even though it was clear he was acting on behalf of the Ukrainian embassy. And this is what was bizarre. The Ukrainian embassy was not a plaintiff, but it was clear that he was acting upon their instructions and their authorizations. He made it clear it wasn't sort of hidden in any way. This was a purely political question. It was, there should have been no one withstanding, meaning this was not even a case brought on by some kind of potential refugee or whatever it was. It was sort of the most clear-cut example of something where there's nobody withstanding and it's a pure political question, and yet the court entertained it and heard it and even gave interim sort of relief, interim injunctions against, and essentially basically dismantled the entire immigration policy on this issue from the Minister of Interior. I should say, by the way, the judge doing so did it on the basis of quoting prose. She quoted songs by Israel's sort of national, or some of our most famous poets. This was sort of the basis upon which the judge who did this based her injunction. This is just sort of to show you what the Israeli legal system looks like today. So yes, these are questions of incredible importance. They're deeply related, like Professor Alford said, deeply related to the way that a court perceives itself. I should say Justice Antonin Scalia has a wonderful essay called Standing as an Essential Element of the Separation of Powers. And just to make the point that standing is not some technical issue, it's not a formality. It's the very idea that the court is there to resolve actual disputes and to give remedy to distinct grievances. It's not there to review policy at large in abstract terms. And that's, in Israel, that's absolutely what we have, a little bit like what Professor Alford described.
So we're going to end it there. Thank you very much, Yonatan, for so quickly stepping in the shoes of Natasha. Again, we wish Natasha well. Hope she gets better soon. I'm sure she will. Ryan, thank you very much. As always, it's a pleasure listening to you talk about these issues. For our Canadian lawyers, you may know that the Law Society of Ontario, if you're from Ontario, is having its bencher elections. We have self-government here. For the British lawyers, we elect our board of directors to the Law Society, and I know Ryan is running, so I encourage people to vote for Ryan. As a matter of fact, I saw another person, Cecil Lyon, who's also amongst us. I encourage people to vote for Cecil. I know if I gave the floor to Ryan, he would say, "Oh yes, don't worry." He would say, "Please vote for Sam," because he too is.
I will say that explicitly, Sam, my distinguished colleague for the past 4 years on that board.
Thanks. Shameless promotion. I'd like to thank Carolyn Turner for being our tech person. Again, I'd like to thank Jonathan Turner for helping me and putting me in touch with Natasha. Thank you very much, Jonathan. For you people, British jurists, the UKLFI Charitable Trust has another program, April 16th, dealing with this issue. The speakers will be Yuval Shani and Abi Bell. For those people in Ontario who are members of the Natus Law Society, we are going to have an event on April 19th. We're joining with the Law Society of Ontario on a Holocaust memorial. The topic is going to be about communications and how the Nazi regime actually used technology like the radio to advance its ideology. So thank you everyone for attending, and everyone have a kosher Pesach. Thank you.
Thank you very much.